A very good evening to one and all present here. So today I'll be speaking about the various types of deeds or agreements that are there or prevalent in the real estate field. There are a lot of them, but I've picked up a few which I think are important. So I'll be briefly touching upon the nomenclature and what is the type of the agreement that I'll be talking about. And then we'll be discussing a brief leave and license agreement, the different terms, the different clauses which should be kept in mind while drafting a leave and license agreement. And then I'll be showing you at the end of the session a sample leave and license agreement, which is very simple in the terms. Now, moving ahead, now several transactions affect the immovable property in the form of lease or say sale, mortgage, partition, etc. Now, what do you mean by the various types of agreements or deeds which are related to immovable property? They can be classified as the leave and license agreement. Now, understanding what a leave and license agreement is, one second. One second. Yeah, a leave and license agreement is a document that basically bestows the licensee with the permission. Uh, yeah, with the permission to occupy the licensor's property. Now, when we say that, that means that the occupancy, which is granted in leave and license agreement, is on a temporary basis and not a tenancy basis. Now, such an agreement makes eviction very easier and is generally provides the landlord with a greater general power. Now, to understand that, we need to give me 1 second because I'm having some network issues. Yeah, so sorry for the chaos. Now, leave and license agreement is very different from the leases. So, to us to understand that, leases create an interest in property, whereas the former does not. So leases are also transferable, which is not the case in a leave and license agreement. Moving ahead, the development agreement. Now, a development agreement is a voluntary contact between a local jurisdiction and a person who owns or controls the property within the jurisdiction, detailing the obligation of both the parties and specifying the standard terms and conditions that will govern the development of the property. For example, if I have a vacant land and I need to construct a apartment or a flat based system on that vacant land, I will simply enter into a development agreement with the developer where the land rights will belong to me, but the development rights of the flat system or the apartment system which is constructed will be divided in the terms and conditions as we sign the development agreement. Now, to understand more in detail, a development agreement provides assurances to the developer that the development regulations that apply to the project will not at all, like they will not change during the term of the entire agreement. It is a fixed understanding which is recorded in the form of a development agreement. Moving ahead, agreement to sell. Mostly people get very confused within the terms agreement to sell and agreement for sale. Understanding that, now agreement to sell is an important document in the process of sale and purchase of property. Now, what do you understand that? This means that this agreement contains the terms and conditions agreed upon between the parties and binds them. Now, an agreement to sell is the very basic document, to be very honest. So, on which the deed of conveyance or any deed which conveys the title of the property is drafted. Now, it is to move ahead or to fix the terms of the understanding between the two parties, it is always advisable to have an agreement to sell in writing. Now, if we understand, the agreement also specifies the different procedures which are supposed to be followed leading to the execution of the conveyance or sale deed. So basically what I mean to say is it records the understanding reached between the two parties and is binding on both the things. Now, memorandum of understanding. It is a document that expresses mutual accord on an issue between either two or more parties. Now, this document constitutes whether a binding contract or only on the presence or absence of well-defined legal elements in the text of the proper document. It depends upon the terms and conditions of the drafting or recording the conditions of the memorandum of understanding. Now, what do you mean by to be legally operative memorandum of understanding? It means that it should record the understanding identifying the both the contracting parties. It should spell out the subject matter of the agreement and its objectives. It should summarize the essential terms of the agreement, and it must be signed by all the contracting parties. So usually before entering into an MOU, people usually enter into a letter of intent. We had discussed yesterday what a letter of intent is. It is a formally non-binding letter which is records the understanding of both the parties. Now coming to the next agreement, it is agreement for sale. Having understood what an agreement to sell is, an agreement for sale is an agreement to sell of property but in the future. Now, to give you a clear picture, you might say that this agreement specifies all the terms and conditions under which the property in question will be transferred. Now, you know that the Transfer of Property Act 1882, it regulates the matters dealing with the sale and transfer of house property. It will also define the contract for sale and an agreement for sale as under. I'm reading out the under quoted. A contract for the sale of immovable property is a contract that a sale of such property shall take place on the terms settled between the parties. It is section 54. Now, from the above definition, it becomes very clear that an agreement for sale definitely contains a promise to transfer a certain property, immovable property, for instance, in question, but in future. Why future? Because the agreement will lay down certain different terms and conditions which the parties will need to satisfy, and upon that, upon the satisfying that certain conditions, the property will be transferred. So the agreement for sale does not itself create any rights or interest in the property for the proposed buyer. Now coming to the next deed, sale deed, it is a legal document that we know which proves that the seller has transferred the absolute ownership of the property to the purchaser. Now when we say it is absolutely transferred the ownership of the property, it means that the complete rights and interests in the property are acquired by a completely new owner. Now, what will a sale deed usually consist of? Now, it consists of the basic following information. Apart from the other deeds and agreements, these are the other, it consists of the details of the buyers, which is similar in the rest of the agreements. It will consist of the property description. It will specifically consist that the sale, which, the amount, which is including the advance payment paid as well as the defined mode of payment. Now, the time frame when the property title will be actually passed to the buyer, when is the actual date of delivery of the possession, etc. Now, can we move to the next slide? Yes. So this is a very interesting case by Supreme Court of India in 2012. Suraj Lam and Industries Limited versus State of Haryana. So in this case, they were dealing with the validity of sales of immovable property, but they were made through a power of attorney and not any of these agreements or deeds which are specified. Now, what did the court say? That immovable property can be transferred or conveyed only by a deed of conveyance, for example, sale deed. Now, which is duly stamped, which is compulsory, registered, which is required by law. Now, we therefore reiterate that the immovable property can be legally and lawfully transferred or conveyed only by a registered deed of conveyance. Now, for us to say, if you see any contract of sale, you can see that as an agreement to sell, which is not registered. So the deed of conveyance, that is the sale deed, would fall short of the requirements under section 54 and 55 of the TOPA. And therefore, agreement to sell will not confer any title, nor it will transfer any interest in an immovable property. Now, according to the TOPA, an agreement for sale, whether with the possession or without the possession, is not a conveyance. Now, when you refer to section 54 very specifically of TOPA, it enacts that the sale of an immovable property can only be made by a registered instrument, and an agreement for sale does not at all create any right or interest charge on its subject matter. Moving ahead, can we have the next slide? Yes, moving ahead, understanding the different clauses or terms of a leave and license agreement. Now, uh, there are very few basic clauses which are required under law and which might be common to lot of agreements. For example, when you see the name clause. Now, the name clause should, now we'll be very specifically talking about the leave and license agreement. So therefore, I'll be talking about the leave and license agreement draft. So the name clause should specify the names of the licensor, and the licensee should be mentioned along with the registered address of the respective parties. Moving ahead, start and end date. It is very important to understand when does the agreement start and when it does it end, because since in a leave and license agreement we will be giving them a license to use the property. So it is very important for the lessor to understand for how long the property is going to be in a use for a certain specific purpose. Now, use of the premises. So in this clause, what happens is the licensor can impose different conditions regarding the use of the premises. Example, like the license's responsibility to not create any nuisance or not to carry out any illegal activities which is not permitted in law, because ideally it is his property which the licensee is using on the behalf of an agreement. So any activities which are carried out should not be invalid or illegal in law. Lock-in period. Now what happens is sometimes both the parties enter into an agreement, for example, say for a period of 5 years. So initially the lessee gives the lessor a deposit or a sum of security deposit in the form of money, apart from the rent or a license fee which is supposed to be paid as a consideration under the agreement. So when the security deposit is paid, the lessee wants to be very sure, or the licensee needs to be very sure that the licensor does not back out or does not withdraw or does not back out from the leave and license agreement which they have entered into. So as a security, the lock-in period for the licensor and the licensee is usually 2 months or 3 months. So if they break in, so usually for a 5-year lease agreement, what I've seen is the lock-in period is of 36 months. So if any one of them breaks the agreement or does not follow the agreement and decides to not go ahead with the leave and license according to the terms of the agreement, they have to pay certain penalty or fee which imposes a hefty amounts, and at times the licensee will not get the security deposit back which is deposited with the licensor. So when we move ahead, yes, now repairs. What happens is I am giving you one of my flat as for a specific commercial purposes. So if you try to change the structural, basically there are pillars and you don't want the pillars. So you are under law, you are not allowed to make any structural changes or alterations or carry out repairs on your own or without the permission of the licensor, because leave and license is merely me giving you a flat for your commercial use. So you are not allowed to change the structure, you are not allowed to make any alterations or carry out any repairs on your own which will change the structure of the apartment. So there are few repairs which actually are needed. Sometimes AC is not working, so the AC pipes, air ducts which we call, so they are not working. So as a licensor I am under an obligation to mention to the licensee the exact position of the flat or an apartment or a space or my licensed property, and give them an exact idea ki what repairs are needed, what repairs are not needed, how is the condition of the property, etc. So next point brings me to the alterations. Now usually the tenants can't make any changes to the property as I said, and usually the leave and license agreement itself contains some guidelines what can be done and what can't be done. So as I mentioned earlier, structural changes are usually not allowed. Now there are I didn't mention this earlier, but there are few leave and license agreement which are known as specifically rent agreements, which are only for a period of 11 months. Now why 11 months? Because any agreement preceding 11 months have to be registered under an law. So you incur all stamp duty or you incur registration charges, whereas the rent agreement of 11 months will not incur any extra charges as such. So people who are looking for short term arrangements, they usually enter into a rent agreements. So contracts of over 11 months or those that are renewed every 11 months should also specify, in addition to the use of premises, that if the flat needs to be painted or if the repairs that are carried out for the maintenance of the flat, so that the licensee can recover those expenses which are not the licensee's liability from the licensor, and they usually are deducted from the license fee. Now the mode of payment. So the agreement should mention that what is the amount to be paid and when it needs to be paid. For example, usually what happens is my agreement will very specifically mention that XYZ amount is payable by every 5th of the month, or some leave and license agreements which are there for a longer period of time, for example 10 years, 12 years. So what that happens is which are renewed, for example, okay, so what happens is they take quarterly payments. So they say that the payment should be made by first of every quarter months. So quarterly payments are asked. So you do not need to pay monthly. So again, what is the mode of the payment will depend upon the nature of the terms and conditions which are agreed between the licensee and the licensor. Now, security deposit, as I mentioned, usually for the lock-in period, security deposit is deposited and it can be extended to the 2 months rent. It is always kept with the licensor. And for example, if the leave and license agreement is terminated, there are clauses which should mention specifically what happens to the security deposit and how can the licensee take it back from the licensor. Now, why is this security deposit concept? So, what happens is at times when the licensee is leaving from the licensed premises, so they might incur some damages or they might uh, not pay the maintenance charges at times on time. So the licensor will send the licensee that notice to the licensee saying that this payment has to be made. If the licensee does not make any payments, then the licensor can pay out of the security deposit. The same happens likewise. At times, the licensor is under an obligation to maintain the premises, which is not just the licensed premises but the area in and around. So, if the licensor, for example, there is any leak, water leakage, the licensee will give a notice to the licensor saying that this repairs needs to be done. But what if the licensor does not comply with the licensee's needs and it is affecting the nature of the business of the licensee? So what licensee will do is licensee will incur the expenses from his own pocket and he'll deduct that particular amount from the monthly payment. So this is how it is done. When you go ahead, next slide please. It is about returning your deposit. Again, when the licensee is leaving the premises, the licensor ideally is supposed to return the deposit if there is no deductions or payments are made. If the payments are made on licensor's behalf on behalf of the licensee, then they should deduct all the amount, and it will contain a clause within how many certain number of days is the deposit returned. Now, notice period. Now, what happens is due to some reasons, I want to terminate my leave and license agreement. So, usually, this is known as the notice period. Usually, my agreement will contain the specific clauses as how and when can I terminate a leave and license agreement. Now, there are some clauses in which, under natural circumstances or given circumstances, you the licensor or the licensee will not uh, attract penalty for terminating. But for example, as I said, lock-in period, if I decide to terminate, it will attract penalty. So at times what happens is there are few circumstances. For example, force majeure, for example, if you give and it has happened, so you give a notice period of 1 month and you terminate it. In the notice period, the parties have to very specifically mention the name, the person to whom the notice should go, the registered address of that person, and the telephone number or the email ID, example, etc. Now, moving ahead to the escalation clause, usually there's an escalation clause in the agreement that the rent or the license fee will be revised upwards annually. I'm talking about the leave and license agreements which are for a longer duration, because since the terms of the leave and license agreement are fixed for a certain given number of years, for example 5 years, so what happens is the market value drops and sometimes it goes above. So the landlord or the licensor should not incur any expenses on his behalf just because the leave and license agreement is drafted. So annually, usually there is a 5%, 10% increase in the normal leave and license. But again, it depends upon the prevailing market rate or depends upon the understanding of the parties. Now, no tenancy. This clause is very important because this clause restricts that the licensee to transfer or assign or sublet or grant any license or sub-license to another party. For example, if I have given A has given license premises to B, so can B sublet the already given license premises to C? The answer is no. Usually, leave and license agreement, the practice is that there is a no tenancy clause, that once I have given a plot or a apartment on a leave and license basis, my licensee cannot sublet it further. But there are few agreements which allow subletting the premises, of course with the permission of the licensor, and if the licensor is okay with it. When we go ahead to the next slide, possession. Now it's very important that if what happens if the leave and license agreement has been terminated or the period has ended, but the licensee is not giving back the licensor the possession or peaceful possession and is refusing to vacate the premises, then what? So usually the leave and license agreement provides that it has to give back the peaceful possession within certain number of days. If not, then the legal action will be taken. Can we have the next? Yes, so now we'll be seeing a leave and license draft agreement. It's a very simple agreement. Since I've explained to you the basic clauses and terms of a leave and license agreement, I think you will be able to relate it more. Can we have the PDF, please? Yes. So if you see, the nomenclature of the document has to be mentioned above, that is the leave and license agreement. Secondly, when we come ahead, it gives you the date of the execution or the date from which the leave and license agreement starts between the licensor and the licensee. You need to mention the full name of the parties and their address. After that, you need to, that is the name clause which I mentioned about the date, about the name of the parties and the address of the parties. Moving ahead comes the recital clause. Recital is something which you narrate about the property, who has the title to the property. But in leave and license agreement, you just mention what is the license premises, so you give the full description along with the name. If it was, the name was changed, you write now called as such and such property. You mention the area along with the pin code. And for the ease of documentation and for the ease of reading a leave and license agreement, you define that term as the license premises. So as we move ahead, you will see the term license premises is used for the description of the property. Now after that, you will narrate, recite what is happening, what, so it is saying that whereas the licensor has requested the licensee to allow him to use and occupy the license premises as the licensee, and the licensor has agreed to allow the licensee to use the license premises and occupy. So basically you just say ki the licensee has requested to occupy the premises for so and so use. You need to write the use of the premises. You say that the market, the title of the property is clear and there's no problem as such for giving for the license, for the use of the license premises. Then you say that we have this, now it is hereby agreed by and between the parties and the licensor and licensee hereto as follows. That comes the operative part. Now what do you mean by operative part? It means that it will define when the license period has to start, when will it end. It will have various clauses such as what is the license fee, what is the escalation fee, what happens to, what is the lock-in period, what is yeah, what is the lock-in period. Then it also mentions as what happens if any of the party breaches the lock-in period. Can we move ahead? Yeah. So then the recital, after recital comes the operative part. It will mention all the obligations of the licensor as well as the licensee. And in a this is just a draft, but when you actually do a leave and license, it has different covenants from the side of the licensor, that he should not terminate the agreement without informing the licensee. And also on the part of the licensee, you have different covenants saying that no matter what, it cannot carry out any structural changes or any alterations on behalf of licensee without giving licensor any notice. So you mention all the covenants, you mention about the security deposit, license fee, lock-in period, how it is supposed to end, how it is supposed to start, escalation clause, all that comes in the operative part. Then you have the notice clause. As I mentioned, if any of the parties want to terminate the agreement, of course they can terminate the agreement. So these notice clause will specify a person from each of the parties. From a licensor side, I'll mention one party. I'll mention the address to which by registered post the notice clause has to go, and an email ID for the correspondence. Similar from the licensee side, I'll be mentioning name of the party, address for the correspondence, and also email ID if for the any official emails if they have to go. So that is your notice clause. And then you come to the signature clause, wherein both the parties sign and they start with the uh, date of the execution is usually the date of the leave and license agreement, but it is not compulsory. At times when the parties sign, they specifically mention that this agreement should come into execution from this and this date. So this is your signature clause, wherein you sign and your right hand thumb impression is required, and you need two witnesses from the licenser side and the licensee side. So basically we have the name clause, then we have the name clause recital, then we have the operative clause, and then we have the signature clause. So this is how a draft leave and license agreement looks like. So I think we'll be having a break right now, and then after that we can have a question answer session. Yes, I think we can have questions. One question we had was if agreement to sell is required to be registered. Yes, under law, agreement to sell has to be registered. The rest of the two questions are with respect to the stamp duty. So I will not be going into the stamp duty aspect as of now. But anything related to today's session, leave and license agreement, or any clauses or terms if you want me to run through again. Yeah.
Hello.
Hello.
Yeah, this is Mridal Pradhan. I actually wanted to ask you as to can you explain again as to what are the various parts, five parts that you were talking about in the sample draft of leave and license agreement? Can you tell the names?
Yes. So the first one is the name clause, wherein you need to write the names of the parties and the addresses of the parties and the date of the document when it has to be executed. The next comes the the next comes the recital part, wherein you narrate what is your property. When you give the property description, it is has to be defined as the licensed premises. So you don't have to keep defining your property. Once you define as the licensed premises, you can use that throughout the entire document. Name clause, recital as in when you recite what your property is, and you know that the title to the property is free and marketable. Then you go to the operative part. Now operative part usually contains lot of clauses such as what is the license fee that is supposed to be paid, or what is the security deposit, how can you refund the security deposit, how escalation clause, what I was talking about. So that can be yes, sorry. So that can be mentioned in the operative part. And the last, then I talked about the notice clause. So notice clause refers to, now if I want to terminate my leave and license agreement, there has to be a correspondence. So under the court of law, what will happen is the notice clause will mention one party from both the sides, from the licensor side and the licensee side. So if I give the notice of a termination to an employee of the licensee side, so will that be counted as a office like official notice period served? No. There in a leave and license agreement, a notice clause is very specific. The person mentioned on behalf of the licensor should receive my should receive my official document saying that I wish to terminate my agreement for so and so reasons. And then if that person acknowledges it or receives it, then it is called as an official communication, even in the eyes of laws. So that notice clause is there. And then we have the signature clause, wherein to both the parties, the licensor and the licensee, sign with respect in front of their names. They put their passport size photographs, they give their right hand thumb impression, and we have the witnesses. Now what happens is, how will I come to know as a registrar or as the third person that this person has signed willingly? So the witnesses kind of vouch for that particular licensee and the licensor. So they have to be two different witnesses saying that yes, this agreement has been executed in my front, but you do not write that it's given, so they just have to sign. So just to come again, name clause, recital, operative clause, and the signature clause.
Thank you.
I hope, yes, yeah.
And
There
yeah,
was,
one more question was there. If
yeah.
you could tell us the difference, again explain the difference between the leave and license agreement and the lease agreement.
Okay, so now the basic difference, if we see, leave and license is usually for a very shorter period of time. For example, for 5 years, 6 years, or usually people do not go about that. If they want to extend the leave and license agreement for a certain period, they keep the renewal option open in one of the clauses. So leave and license agreement gives you a permit to use the place under specified terms and conditions which are recorded in a leave and license agreement, whereas a lease agreement is always for a specific number of years. It can extend to the 99 years or 999 years. So in that, what happens is, the restriction for the enjoyment of the property which is there in the leave and license agreement is not present in a leave and license agreement. So when you enter into a leave and license agreement, there are a lot of restrictions. The user is permitted to use the premises under A and B conditions, but in a lease, whereas the lessor or the lessee has a huge benefit, or huge, they can enjoy the property in a more unrestricted manner as compared to a leave and license agreement. So therefore, people, if they want to go for a shorter term, they usually go for a leave and license agreement. If it is for a longer period, if they don't want to renew the agreement again and again, they go for the lease agreement.
Thank you, ma'am.
I hope that was helpful. Yes. There was this one more question with respect to deed and agreement. Now, a deed is specifically given when the conveyance of the property or the title is conveyed. But whereas in an agreement, if you see, the conveyance is dependent on few conditions being satisfied, and it is always in a future. So when you see a sale deed, when A and B sign a sale deed, the conveyance of the property is from that effect, from the date of the execution of the sale deed. But if you see an agreement to sell, and in an agreement to project on and after 25th of uh, March actually, but with respect to now, if you see, force majeure actually does not under RERA does not cover the definition of no pandemic situation. So RERA has given force majeure to be treated to the pandemic to be treated as a force majeure. But when you see leave and license agreement or the it depends actually on the construction of the agreement. It will mostly determine if there is a non-payment of rent. It will be construed from the terms and conditions to which the parties have agreed to. Now when the court, I think when they'll look, if you ask me personally, when they look into the interpretation of the document, and if it does not even contain any clause with respect to the pandemic, and the office is being shut, or you're being operational because of these calamities or these situation, then I don't think so rent waiver is a solution. And I think Delhi High Court recently has also rejected it, and they have said ki non-payment of rent is not the solution, and they will be liable to pay again depending on the uh, conditions or the construction of the document. Basically, if there's any actually what do we say, uh, if you see if there is any clashes with respect to the situation or with respect to any other circumstance, what do you see is basic. You see your document. How does your document provide you in the first instance? How does the document try to involve the scope? Does it cover the pandemic situation? Yes, no. If it doesn't cover, then ideally you will be liable to pay the rent.
काय अगं आई माझं सेशन सुरू आहे.
Yeah, I hope, Parul, I was able to answer your question.
Ma'am,
Yes,
again it's Mrinal.
yes.
Yeah. For further reading of this topic, can you suggest any courses or diploma courses which students can take?
So, to be very honest, I haven't actually come across any diploma courses or any certificate courses pertaining to the real estate topic as such. Because if you see, the real estate will be affected by different laws given the area that you are in. As yesterday I mentioned, if you see the Bandra property, MMRDA comes into picture. If you go towards the south, different authority comes into the picture. But there are certificate courses on RERA, as I have come across. They give you, I think, a month or two online certificate courses. I think there are no more questions.
Okay, so if there are no more questions to ask, considering there are no more questions to ask, I would like to thank ma'am for sparing her time out and sharing her knowledge on real estate laws.
Thank you, Akash and Team Tathya, for having me. It was my pleasure to be here. Thank you.
Okay, thank you so much, guys. Thank you so much for